We'll begin with Kohler versus Albertson. If any of you have cell phones or Blackberries or whatever, we appreciate it if you turn them off. Counsel, are you ready to proceed, sir?
Yes, Your Honor. May it please the court.
How much, let me, excuse me just a minute, let me get this thing reset. How much time do you want to reserve with me?
5 minutes, Your Honor.
All right, you got it. You can
My
begin,
name
sir.
is Daniel Perez. I represent the appellant in this case, Margaret Kohler. Ms. Kohler filed a whistleblower retaliation and a sex discrimination complaint against her former employer, Albertson's Supermarkets, under Florida Statutes 448-102 and the Florida Civil Rights Act, Florida Statutes Chapter 760. This case is on appeal from the lower court's decision on February 2nd, 2005, granting summary judgment in the defendant's favor. This case is about a company that confuses a pharmacist's refusal to disclose private information as insubordination.
Let me ask a question that's bothering me somewhat about the sex discrimination count. And it has to do with whether, these two people, Hammonds and Kohler, were similarly situated employees. And, of course, I've read the briefs and the arguments, and I'm still having a difficult time with that because it appears to me that Hammonds was a staff pharmacist and Kohler was the manager, the pharmacy manager. And that although you make some arguments that they may have been referred to Davis for discipline, I'm still having a difficult time discerning that they were similarly situated. And if they weren't, then why wouldn't summary judgment be appropriate?
Your Honor, the similarly situated argument does not mean that the two employees have to be identical. You need to relate to or look at federal law regarding the similarly situated.
Right, and I'm referring to the Jones case, where it basically seems to indicate to me that as a matter of law that if one is a supervisor and one works under the supervisor, for example, manager of a pharmacy and a staff pharmacist, that as a matter of law they're not similarly situated.
Jones case is very different from this case.
I know you tried to distinguish it in your briefs, but I'm not completely convinced that those distinctions have a big difference here.
Well, the thrust of the Jones case was that Jones admitted his misconduct. He had a long record of misconduct, and in this case, my client is denying misconduct. In my honest opinion, the Jones case was decided in the defendant's favor on account of that.
Okay, well, let me ask you, as a matter of law, do they have to be similarly situated?
They have to be similarly situated in all relevant respects.
Right, and do the federal courts say, as a matter of law, that a supervisor is opposed to someone working on staff under the supervisor, as a matter of law, they are not similarly situated?
Could you repeat your question, Your Honor?
Does, for example, the Jones case, and there are some others, but Jones was cited in the briefs. Does Jones say, as a matter of law, that if a supervisor and someone that works on staff under the supervisor are involved in the situation where there's an alleged sexual discrimination, they're trying to say that they are similarly situated? As a matter of law, don't the federal cases say that they are not?
Well, I do believe that the Jones case, which is a case from outside the 11th Circuit, I believe it's a 6th Circuit court case, does say that. In addition, it says that the plaintiff in that case admitted his misconduct, had a long record of misconduct.
Okay, well, what difference does that make then if, as a matter of law, a supervisor and a staff employee that works under the supervisor cannot be similarly situated as a matter of law? What difference does anything else make?
The question is not just whether they're similarly situated, it's whether they're similarly situated in all relevant respects. And in this case, both my client and her staff pharmacist, remember there were only 2 pharmacists in the pharmacy at the time, it was these 2, were reporting to the store manager. Any performance issues had to be directed to the store manager. In this case,
Well, so are you saying in each and every detail, in each and every respect, they have to be?
no, sir.
Okay. Well, wasn't Kohler the manager of the pharmacy?
Yes, sir.
Right, and wasn't Hammonds a staff pharmacist that kind of worked under her direction and control?
Yes, Your Honor, he was.
And you're saying that despite that they're similarly situated, despite the fact that the federal cases seem to say as a matter of law, in situations like that they're not?
Your Honor, the federal cases say that they have to be similarly situated in all relevant respects. And in this case, they were both of these individuals, both of these pharmacists were placed under the store manager, Nancy Davis, by Bobby Andes. In that respect, they are both similarly situated.
Counsel, it seems to me that what we've got here is a request to look at a computer screen that would have violated the law. But what is there in the record to show that there was an actual violation, that in fact Nancy Davis actually saw medical records that pertain to this particular customer? Or maybe she just saw simply the accounting information and tried to back out a charge that was made. The Board of Pharmacy, when they looked at this case, apparently found that there was no actual violation. What is there in the record to show that there, in fact, was a violation?
Nancy Davis, to my understanding from the record, Your Honor, did not have an opportunity to review the patient's records because, fortunately, my client, who was a gatekeeper to that information, stopped her from doing so.
Well, all right, let's concede that. But doesn't there have to be an actual violation? I mean, if somebody stops them, in other words, what you're saying, your argument is then that if somebody has intent to violate it, that's good enough?
Your Honor, I think it's against the spirit of this law, the whistleblower statute. Remember, the whistleblower statute was passed so that employees can act as attorney generals to enforce the law and make sure that it's not violated in circumstances like these. So I think we'd be putting the cart before the horse if we say, well, there wasn't an issue here because Nancy Davis never actually reviewed the records. And I want to emphasize that the computer records aren't just an accounting record that says what kind of medication this patient was taking. Could have been for mental illness.
Wasn't there some evidence that she attempted to back off on that and indicated, well, I just asked her to check rather than to show me?
That's a disputed material fact. Nancy Davis says that all I wanted her to do was check. My client says that no, she wanted to enter the pharmacy, look at the computer records of this patient.
And is that your disputed issue of fact as to the whistleblower count?
As to the whistleblower count, there's more.
What other disputed issues of fact do you have as to that count?
Well, in our estimation, Your Honor, with regard to the whistleblower allegation, we filed a motion for summary judgment, which we didn't have an opportunity to have it heard before the court issued its decision. But in this motion for summary judgment, we stated the facts as they transpired. Our client filed a complaint with the Board of Pharmacy, complaining about the store manager having to approve her decisions not to refuse or to refuse to fill a prescription. She showed this complaint to the store manager on December 23rd, 1996, and 15 minutes later she was terminated. We asked at deposition Nancy Davis, why did you terminate her? She said insubordination. Nancy Davis testified both at her unemployment compensation hearing and at deposition that the insubordination was Kohler's refusal to show. Let her see this.
Would you say that your strong issue is the issue relating to the request to show me, you know, the information on the computer as opposed to her then backing off on that and saying, well, I just wanted her to check? Would that be your strongest issue of fact here that you think that we should take a look at? What's your best shot here?
Our best shot, Your Honor, is the period of time between when my client objected on December 23rd, 1996, to show Nancy Davis client records. Nancy Davis calls corporate counsel.
Okay, so it has to do with show me the records. Is that basically, I mean, generally the issue I'm talking about, is that generally the best issue here is to, you know, for us to look to see whether there's an issue of fact here?
This case is first and foremost a whistleblower case.
Right, I think so too. But in any event, is that basically your strongest issue, you think, in telling us that there really is an issue of fact here, and it's that show me issue? All right.
Yes, Your Honor.
If a employee who is not a pharmacist makes an attempt to violate the law, the pharmacist is if the pharmacist is aware of it, it's the pharmacist's responsibility to thwart that attempt, right?
Yes, Your Honor.
And isn't that essentially what happened here? You had someone who was not a pharmacist make an attempt to violate the law,
That's correct.
and then the pharmacist was successful in thwarting that attempt, right?
That's correct, Your Honor.
So I guess maybe this bears on Judge Boyce's question. Is blowing the whistle about an unsuccessful attempt to violate the law call into play the whistleblower statute?
Yes, Your Honor. Because
Can you help me with the language of the statute and what you're relying on in the language of the statute?
448-103-102 Section 3 states that the employee is protected if she objects regarding a violation of law, rule, or regulation. It would be absurd, Your Honor, for us to read that statute so narrowly that an employee who thwarts the attempt to violate the laws established by the Florida legislature would not be protected by this statute.
Okay, well, let's get to 3, okay? So you focus me in on that. Your client objected to or refused to participate in.
That's correct.
Certainly not a policy or practice of the employer, but arguably an activity of the employer.
Yes, Your Honor.
Is that your argument?
Yes, Your Honor.
Okay.
Doesn't an activity, though, have to involve more than one isolated incident? I mean, the word just, to me, implies that there's some kind of an ongoing series of events and not just one isolated situation.
And there were, Your Honor. My client, after December 9th, she was given a directive to go get confirmation from a store manager when she refused to fill a prescription. And on at least 2 occasions before the 3rd incident, she would have to go to the store manager, tell him this is the prescription we're trying to get filled. Let me tell you why I don't think it should be filled.
But there were reasons why they were imposing that requirement upon her. She was insubordinate. She was running customers off. All of these other things that she was doing. It seems a perfectly natural restriction to place on her. I don't think that violates any law, does it?
That's a material dispute of fact, Your Honor, because my client testified that she gave good customer service. There are no negative performance evaluations in this case. She received 2 awards for excellent customer service because people called in. She had excellent sales. There was 1 incident with a customer who became belligerent with her in November, late December of '96, which precipitated that instruction.
Well, let's assume that she had a lot of satisfied customers and 1 belligerent customer. Does that change your argument at all?
The belligerent customer wasn't her fault, Your Honor. The belligerent customer became belligerent because he alleged in front of the other customers that she had misfilled his prescription and committed malpractice. Under such circumstances, she was well within her rights to tell the customer to leave the store when he's making such professional accusations that would go to her licensure.
Do you agree that when we're talking about activity, it seems like you may have agreed with Judge Boyce's question that when we're talking about activity, it involves more than just one isolated incident. Do you agree with that, or is this something that needs to be an ongoing series of events?
Well, in this case, there was an activity. There was a There was a policy.
Let's just assume that we take a look at it and say there was this one isolated incident where she went and said, "Show me the computer information, and I want to see it," and Ms. Kohler refused. And that just happened just one time. Is that an activity? And do you interpret the word activity to require more than just one isolated event, or a series of events ongoing?
I think activity could be defined both ways. The statute is extremely broad when it says any activity, any policy, or any practice of the employer. And here, this employer imposed an activity, a policy, a practice that required my client, the licensed gatekeeper to these controlled substances, to have to go get approval from someone else who's not a pharmacist whenever she refused to fill a prescription. That's the activity, the policy that was set in place, the practice that Albertson's just run. I'd like to reserve the rest of my time.
You've got 5 more minutes. Counsel, hang on just a minute here. Okay, you may begin, sir.
May it please the Court, David Baruch, on behalf of Albertson's Incorporated. Let me first address the critical, undisputed fact that has not yet been mentioned in this argument. Ms. Kohler was called into a disciplinary meeting by her superior, the store director, on December 23, 1996. This was Kohler's last chance. She was given a written document entitled Final Warning for Insubordination and Poor Customer Relations. Ms. Kohler laughed at the document. She told the store director, "You have no jurisdiction over me." She said, "The regional pharmacy manager has no jurisdiction over me either." She refused to sign the document.
Well, your client is saying that they had grounds to fire her, separate and apart from retaliation for blowing the whistle, right?
Absolutely, Your Honor.
I mean, that's always the case in these kinds of cases, right? I mean, if that's your defense, that we had good grounds and that we weren't retaliating, that's a question of fact for the jury to decide, isn't it?
No, it's not, Your Honor, not in this case.
Why not? Why not? I mean, isn't that always the position that the employer takes in a retaliatory termination case, that, no, this is not the reason that we fired the employee. This is the reason we fired the employee.
Certainly that is an argument that is regularly made in cases like this. But let me point out...
You didn't even need a reason to fire this employee, right? As long as it wasn't a retaliatory or in violation of some, a statute that protects a particular class of individuals. This is a terminable at-will employee, right?
That is correct, Your Honor. We don't need a reason. We just can't use a discriminatory reason. But I do want to point out, and this is something that's pointed out in the trial court's order, that what happened on December 23rd, in that she received this document, she laughed at it, she said, "You have no jurisdiction over me." And then she said that, "By the way, I've also filed a complaint with the Board of Pharmacy." That is not the protected activity that's alleged here. If you go to their complaint, there is no allegation with respect to that statement. It is not in the complaint. It is not a part of Count 2. It is not an allegation that is at issue in Count 2. Instead, what they have based the Count 2 Whistleblower Protection Act claim on is a dispute that occurred on December 20th. We all have discussed this extensively with Mr. Perez. Let me get into more detail about that. On December 19th, a customer named Ms. Rissinger tried to fulfill a prescription. She was refused. On December 20th, she called Ms. Kohler and told her, "I've got another pharmacy that's going to fill the prescription. However, Albertson's mistakenly entered into the computer that they had already fulfilled it. Therefore, Ms. Rissinger could not get the prescription paid for by Medicaid." She asked Ms. Kohler to please back out the computer or fix the problem with the computer so she could get a prescription. Ms. Kohler hung up on her. These are undisputed facts. Ms. Rissinger called again. Ms. Kohler answered the phone, laughed at the customer, put the phone down, and walked away. At some point during this dispute with the customer, Ms. Kohler told Rissinger, "Well, call Nancy Davis. She's the store director. You complain to her." So Ms. Rissinger calls Nancy Davis, the store director. She explains the problem. That is what prompted Miss Davis to go down to the pharmacy counter, and all she did was ask her to check, and let's concede, let's just say...
Yeah, but it's more than that, because there's evidence that she said, show me.
Right.
What's in the computer. And then she tried to back out of it and then say, well, what I really meant was check, which wasn't an illegal activity. But if Davis said, show me what's in the computer, I want to see it, that would be illegal, wouldn't it?
No, it would not.
Would not? It's not improper?
It would not, no, Your Honor. Let's concede that she said show. She said, show me on the computer, where on the computer it says she either paid cash or she paid Medicaid. That is hardly a privacy matter. This allegation went to the Board of Pharmacy. They said there's no violation here. Let me point out that...
Counsel, isn't there a disputed fact in that situation? You've described the scenario one way, and opposing counsel's described it another way. It seems to me like we've got a disputed fact here.
I'll concede his description of it. I'll concede that she went to the pharmacy counter and said, show me where on the computer it says that Ms. Rissinger paid cash or it was charged to Medicaid. Let's concede that point. That is not a violation. It is not a violation. Consider that there are non-pharmacists behind the counter looking at this confidential information. This is a regular practice across pharmacies all over the United States.
Counsel, let me shift gears a minute. Let's assume you've got an employee who is really difficult to deal with. She's running off customers. She's insubordinate. She wants to do her own show. And yet you also have a whistleblower situation where there's a violation of an activity that constitutes a violation. And the whistle is blown by this employee. What's your view on that? Does the employer at that point never totally unable to fire this person?
Well, it's an interesting scenario. Certainly they had grounds to terminate her at the December 23rd meeting. Can she save herself, despite the clear, undisputed insubordination that she committed, by saying there's been a violation? What she has to prove is that there is an actual violation. There was no actual violation in this case.
Well, let's assume that there is an actual violation. In my hypothetical, let's assume that there is an actual violation. Is it your view that then the person can still be fired, or that the person can never be fired because of the report of that violation?
I would think that the person could still be fired, and it depends on whether or not the motivation for the firing was the reporting of the actual violation.
There's your issue of fact that needs to be decided by the trial court. Isn't that basically right? Well, why was she fired? For insubordination, or because she blew the whistle on some illegal activity?
Well, again, the complaint to the Board of Pharmacy is not alleging the complaint. It is not a part of the whistleblower count. The only thing that is alleged on count 2 is that she prevented Ms. Davis from seeing a computer screen. And that is not an actual violation of the law as required under 448-1032. Now, let me make clear the point about hiring.
If you're wrong about that, if that is a violation of the law, then we should reverse, right?
No, Your Honor.
Why not?
Because there is no causal connection between that and between her termination. It is very clear what happened on December 23rd. It is undisputed. There's a very clear hierarchy in every Albertsons store. The store director oversees all of the managers, the deli manager, the bakery manager, the pharmacy manager. Because of special considerations that apply to the practice of pharmacy, there is also a regional pharmacy manager. In this case, it was Robert Andes. Ms. Davis is her superior. Mr. Andes is her superior. So she walks into the meeting on December 23rd and says to her superior, Nancy Davis, you have no jurisdiction over me. Mr. Andes, a licensed pharmacist, has no jurisdiction over me. She laughs at the written warning. That is clear insubordination in a meeting that was about insubordination. She walked into a disciplinary meeting about insubordination and committed yet more insubordination. She was terminated for that reason. That was the basis for it. There is no causal connection between the attempt to view the record, to view a computer screen.
It seems to me that you're presenting an argument that really goes to your client's intent, which is a motive, which is really classically a question of fact, isn't it?
Your Honor, the Board of Pharmacy looked at that scenario and said there has been no violation.
Well, the Board of Pharmacy was charged with the responsibility for determining whether a violation of the law had occurred. And counsel's theory is that his client thwarted the violation by refusing to allow Ms. Davis to look at the computer. I mean, that's their theory, and they're hanging their hat specifically on paren 3 of the statute. And you know, that's why I asked you before. You know, if in fact, if Ms. Davis had been able to carry out her demand, show me the computer. In other words, if the plaintiff had acquiesced to that demand, would that have been a violation of the law?
We take the position that no, it wouldn't have.
Okay, well, tell me why that isn't a violation of the law.
Your Honor, it's not a violation because of the interpretation of the pharmaceutical rules, of the regulations that apply. You have non-pharmacists looking at those records on a daily basis. It's people who are non-pharmacists subordinate to, in this case, Ms. Kohler.
So a non-pharmacist who works for Albertson's has the right to look at, you know, my confidential, you know, patient records, is what you're saying?
Your Honor, when you go get a prescription, you are most likely talking to a non-pharmacist. My 17-year-old niece works behind a pharmacy counter. That is a regular.
Well, they work under the direction. I mean, when I go talk to, when I talk to the doctor's office, I'm talking to a receptionist too. But I expect that she works under the, the penumbra of the doctor and all of the privacy rights that I have. That doctor's responsible for enforcing those. This kind of a different situation here. The pharmacist didn't want her to look at the information, right? I mean, can a janitor go look at the, this information?
No, Your Honor, I wouldn't think so, but a janitor does not stand in the same position as the superior to the pharmacist. And all she was asking to see was show me where on the record it indicates that she paid.
Well, what does the rule say? I mean, what is the law as it relates to non-pharmacists' access to this type of information?
Your Honor, I don't know specifically. I don't have that in front of me. But clearly the Board of Pharmacy did not interpret, the agency with jurisdiction over these regulations did not interpret.
Well, just paraphrase the rule for me. I mean,
Your Honor, I think that there is a certain confidentiality that attaches to those pharmacy records. Now, it is an enormous stretch to state that Ms. Kohler was concerned about Ms. Rissinger's privacy. She had directed Ms. Rissinger to talk to Ms. Davis. Ms. Davis, at Ms. Rissinger's request, came to the pharmacy counter. All she wanted to see was essentially a cash register issue. Did she pay cash when she charged Medicaid? She didn't see the record. 448-1023 requires an actual violation. There was no violation in this case.
Well, what about paren 3, where it says that if the plaintiff has refused to participate in any activity, that's a violation?
And I think the important language there is in violation of a law, rule, or regulation. What the case authority says is there has to be proof of an actual violation.
So you work for a developer and they're about to excavate a bunch of wetlands, and let's say you're the machine operator, and you're the only one that knows how to run the backhoe. And you tell your developer employer that it would be against the law to excavate all these wetlands. So I'm not going to turn the machine on. And in fact, I'm going to report you to the DEP. And the next day, you get fired for that. The DEP comes in and they put a cease and desist order on the developer for any further development. They save the wetlands. There's never been a violation. Are you telling me that employee doesn't have a whistleblower claim?
Your Honor, what's different about the analogy is the report to the DEP. There is no allegation that the alleged report, did go forward to the Board of Pharmacy as a part of this Count 2 claim. I think this maybe goes to a question that was asked earlier. Does it require?
So as long as the employer fires them before they communicate, in other words, if they refuse to participate in an illegal activity, and they tell the employer that it is illegal and they're not going to do it, and moreover they're going to report them for violating it, violating the law, attempting to violate the law. As long as the employer terminates them before they're able to communicate this, then the whistleblower statute is not implicated.
The statute requires an actual violation. I would think that requires proof of violation of the law through all of its elements. And I think maybe this goes to a question of whether it's an activity, a repeated course of conduct.
Do you have any case law that says that it requires an actual violation rather than an attempt to get the employee to participate, and the employee refuses and thwarts the actual commission of the illegal activity? Do you have a case that says that?
Your Honor, I don't believe the case law that we have on this point is that detailed. There certainly are cases that say an actual violation is required, and that's based upon the plain language of the statute. There are two cases out of the Middle District of Florida that state exactly that proposition. There's been another case out of the Middle District which also makes that determination. That came out just recently. I'll submit that as supplemental authority later this week. It says that an actual violation is required in order to trigger the statute. Had the complaint to the Board of Pharmacy been a part of the
But isn't attempting to get the employee to participate in illegal activity a violation? You're saying that my question is, does the criminal act have to be completed in order for there to be a violation, or does the employee just have to attempt to coerce the employee into participating in illegal activity, and then the employee refuses and then blows the whistle, and there really was no completion of the criminal act?
Your Honor, I think under the statute there has to be a completion. There has to be an actual violation. But again, we are far afield of what actually happened in this case.
Before your time expires, I did want to ask a quick question about your request for attorney's fees. And it has to do with when they were given notice that you would be seeking fees. And, does notice have to be given and when? And so, are you following me on that? When were they placed on notice that you're going to be seeking fees in this case?
Your Honor, that is, I believe, a correct statement, that under the Stockman rule, the notice has to be given.
When did you give notice?
Your Honor, standing here, I don't know. I would have to go back and review the record.
You didn't give notice, and you're seeking fees for work done prior to the time you gave the notice. You would concede that you're not entitled to fees.
The fees would begin to run at the time notice was provided. I am running out of time. Let me talk briefly about count one, which is the gender discrimination claim. The court found that Ms. Kohler did not state a prima facie case of gender discrimination, and essentially she failed on the element of there was no similarly situated male employee who was a valid comparator. She had Alston Hammonds cited as the comparator. As was spoken of, Mr. Hammonds was her subordinate. If there was any discipline to be handed out to Mr. Hammonds, that was Ms. Kohler's responsibility. She testified that she did not follow up with a written complaint about Mr. Hammonds because she didn't want to create a bad feeling, a bad atmosphere around the pharmacy. He was not a manager. He was subordinate to her. He did not engage in the same misconduct that she did. He's simply not a valid comparator. So I think summary judgment is certainly valid on that count for that reason. Mr. Perez stated that there was a policy that Albertson's required Ms. Kohler to get permission before filling a prescription or refusing to fill the prescription. There is no record evidence to support that assertion. In our answer brief, we collected all of the citations that they used to support that assertion, formed a long string citation, and we stated categorically none of these support their position. In their reply brief, they respond to that argument in 2 paragraphs, and that long string cite was whittled down to 3 documents. It was whittled down to 2 pharmacy logs that she took upon herself on her own initiative to get signatures. It was not anything, and this is undisputed, it was not anything that had to do with an Albertson's policy. And the third document is the final warning for insubordination and poor customer relations that I mentioned. What they focus on in that document is a statement that Ms. Kohler shall have to have a rational basis. She can refuse to fill a prescription, but she has to have a rational basis. they focus on the rational basis language and say that that is something that intrudes upon her authority in pharmacy. Certainly would seem self-evidently legitimate that Albertson's can require its employees to have a rational basis before refusing to fill a prescription. That is something that could be monitored by somebody like Robert Andes, her superior, a licensed pharmacist, someone in the chain of command above her. So this notion that there is a policy that she was required to obtain permission before filling a prescription is simply not supported in the record. And I point out there is no deposition testimony from KOHLER. There is no affidavit from KOHLER supporting the existence of such a policy.
Got about a minute left.
Unless there are further questions, Your Honor, what I would ask is that the court affirm the summary judgment granted below. The undisputed facts compel the summary judgment, particularly the events of December 23rd, the termination meeting. Ms. KOHLER does not dispute her insubordinate conduct at that meeting. There's no dispute whatsoever. That was clear grounds for termination. Thank you.
Opposing counsel alleges that
Mr. Perez, let me ask you a question.
Yes, sir.
Focus me in on, and I'm asking you for a citation to a statute or a rule or something like that, of what exactly the violation would have been had the plaintiff shown the computer records of Ms. Davis.
Yes, Your Honor. Florida Statutes 465.0172 says that pharmacy records shall not be furnished to any person except the patient, patient's legal representative, a party with a subpoena, the Florida Department of Health, and interestingly, the patient's spouse, but only if the patient is incapacitated and that patient gave the spouse prior written consent. That's how strict the statute is.
So you're saying that when a corporate entity employs a pharmacist, and as a result of that, the corporate entity has records that relate to a patient, that nobody in that corporate entity can view those records except for a licensed pharmacist. Is that what you're saying?
And the people under the pharmacist's employ.
Clerks and things like that.
Pharmacy techs, I believe
Well, who would be the custodian of those records?
the pharmacist. In fact, when Albertson's,
If somebody wanted to subpoena those records, for example, wouldn't they subpoena Albertson's to get the records?
I believe they would, yes, Your Honor.
I mean, aren't they corporate records? Don't they belong to the corporation?
Well, I don't think so, Your Honor, because a supermarket can't just open a pharmacy. They have to go apply for a permit with the government in order to establish that business. That business is separate and apart from the baker, the meat department. There are separate rules that govern this entity, this pharmacy, this practice of pharmacy. Albertson states that my client allegedly laughed at Nancy Davis when she was presented with the written warning. That's not true. There were 4 people at that meeting: KOHLER, her husband, and assistant manager Baroque.
What difference does it make whether she laughed or sat there with a stone face? I mean, how is that relevant to this case?
It isn't. My client didn't laugh. The only reason that this is being alleged is in order to criticize her and make her seem like she's an insubordinate employee when all she was a hard-working pharmacist who put the pharmacy first, put her customers first. She received awards and accolades for that customer service.
So let me go back to what is meant by any records in 469.0172. I think opposing counsel indicated that, well, she just wanted to know about billing, and that sort of thing, and not really the substance of any other records that may have been in the computer. Are the billing is the billing data covered by any records under 469? under that particular statute or not?
I believe so, Your Honor, because it's not just the billing records, the type of medication that's being
Yeah,
taken.
but what if opposing counsel was correct and the record indicates that I just wanted you to show me whether the billing was backed out or whether the billing was actually paid? The only concern was billing and whether, that had occurred or not.
That's still a record of the pharmacy. And in fact, the defense hired the dean of the University of Florida School of Pharmacy, and he testified that, yes, it would have been a violation of 465.0172 for my client to have shown Davis these records. I mean,
You have an expert witness that testifies as to what the violation of the law is?
we have an admission. We have an admission from the dean of the University of Florida. I don't think I can argue that I know better than him on that score.
You've got an FSU and a Stetson graduate, so I don't know whether they're that impressed with the fact.
All right, so you're saying any record covers, any documentation relating only to billing too. It encompasses everything, and therefore that's a violation. Even if we look at the records, all she wanted to do was look at the billing aspect of the data.
This record had more than just billing information. It had the medication. I want to emphasize that my client refused to fill this person's prescription because her doctor told my client that this patient was not supposed to be filling the prescriptions there because she was a drug abuser, and she was supposed to be filling her prescription elsewhere at a pharmacy where the doctor in that pharmacy were monitoring her drug use. And in fact, the expert witness in this case, Dr. Doring, testified that it would have caused them pause to have granted this patient the huge amounts of Stadol, Bucranix, in injectable and inhalable forms that she wanted.
Counsel, your time.
Appellant requests that the court reverse the law.
Right.